Good morning and welcome to the Moorcrofts Employment Law Update webinar. And also welcome to my colleague, Lindsay Abbott. Lindsay's a solicitor in the employment team, works closely alongside me, and Lindsay's going to be helping me present today. And that's great to be able to get the both of us speaking to you on those things. And welcome to everyone who's joined. Slightly different circumstances to our normal seminars. You know, in the past, we've had some lovely venues. We've been down at Bisham Abbey and places like that. But I think by doing it as a webinar, it probably allows more people to join than we would have had normally anyway. So that's great. And normally at this stage of any seminar, I'd be reading out the normal housekeeping requirements, things about, you know, where the facilities are, how we're not expecting any fire drills or anything like that. Slightly different in the world of webinars, isn't it? So perhaps I should start by saying I'm not expecting any Amazon deliveries. That apologies if random children walk in and ask for food, which seems to be the main theme at the moment. And also the dog is asleep, but if it wakes up and starts barking, don't be alarmed at all. And with that housekeeping out the way, let's have a look at what we're going to look at today. Well, it wouldn't be an employment law update if I didn't touch on the future of the furlough scheme, which has probably dominated certainly my advising life for the last nearly 12 months. And I suspect for a lot of people who are listening to this webinar, it's also had them looking at and considering in great detail as well. But what we didn't want to do was just to concentrate on the future of the furlough scheme. So what Lindsay is then going to do is look at the continued impact of case law, and there certainly has been an impact. And I think the danger is, and we thought when we were putting the slides together, that actually there's been some really interesting cases over the last few months that I think have got a little bit lost in the fog of the furlough scheme and other employment law implications of coronavirus. And then we're going to then have a look in the third section, just at kind of a bit of crystal ball gazing, employment law 2020 on and 21 and beyond, and then hopefully we'll finish up with some questions at the end. There is the Q&A box, so feel free to use that, and what we'll probably do is just answer those towards the end rather than interrupting the flow as we go through. If we get some really good questions and answers there, what we'll probably do is put an FAQ together and circulate that. The session's also being recorded, so for those who want to listen back again, we'll be sending out a link over the next day or so. And also, if for some reason you've got urgent pressing work and you need to dial off at any stage, again, you'll be able to catch up as we go through on that. So hopefully that sounds good. So let me start by looking at the future of the furlough scheme and our favourite Chancellor, Rishi Sunak. Well, the furlough scheme, or to give it its full title, the Coronavirus Job Retention Scheme, was first announced, can you believe it, way back on the 20th of March 2020. So we're nearly celebrating the year anniversary of the furlough scheme. It actually opened for claims on the 20th of April, and those claims were backdated. Those of you, of course, who've used the scheme will know that that scheme has changed in the nature of it. I was looking back at the original guide to the furlough scheme. I think it was something like just an 8-page, single guide to the furlough scheme, which created some issues in itself. But now it's kind of morphed. I think there's 8 sets of guidance notes that go with it. And if, like me, you're subscribed to the government update scheme, so every time they change the furlough scheme, I get an email into my inbox, you'll know there are frequent updates to these 8 or so different guides, sometimes simply because they've added a translation, and other times because they've made a more substantive amendment. And the scheme's changed as we've gone along, particularly in relation to employer contributions. So we had the no contributions were required from the employer to start with. Then in August, it changed so that the employer would have to meet NI and pension contributions. And in September and October, employers were required to contribute more in terms of pay in order to access the scheme. That's changed again this time around. So from November onwards, that those contribution levels have changed yet again. And also been dealing with some difficult issues, haven't we, with the furlough scheme? And I think it was a little bit like trying to build an aeroplane as you're flying along. I think each time they came up with a particular issue, they then had to answer that. And I think holiday pay was probably one of the most tricky ones, and one that I spent a lot of time at the beginning of the furlough scheme talking about. So does holiday continue to accrue during the furlough scheme? Well, we know the answer to that is yes. Can employees take holiday if they've been furloughed? The answer to that is yes. Can you require employees to take holiday during furlough? We know the answer to that now is yes. And what do you pay an employee who takes holiday during furlough, whether that's because they've been required to take it or they've asked to take it? We now know that should be their normal salary. And certainly before those questions were answered by the various guides, we were having to guess a little bit. I'd like to think my track record was pretty good. I think I was 4 for 4 on guessing those things. And it slightly more, I'd like to think it was an educated guess, but still there was an element of, I think, debate in there. So we have seen some tricky issues as we've gone along with the scheme. I thought it was just worth highlighting with the furlough scheme some of the numbers involved. If we look at the 15th of February 2021 as a snapshot and a cumulative total, 11.2 million jobs have been furloughed in that time. And 1.3 million employers have benefited under the scheme. And the cost, a fairly eye-watering 53.8 billion claims. And remember, we've still got, as of the 15th of February, when those stats came out, we've still got another 2.5 months of the scheme to go. So expect that cost to go up. The peak of the scheme was the 8th of May 2020, I'm reliably informed by the government statisticians. And at that stage, quite remarkably, we saw 8.9 million employees furloughed. And that's out of roughly a working population of circa 33 million. So you can see the huge amount of employees that have been furloughed at that time, and perhaps the impact that we would have had on jobs had the furlough scheme not been in place. That take-up rate really does show it was well used. Current stats for January 2020 show that 4.7 million employees were furloughed during that time. And what you saw, certainly from the May peak onwards, was a gradual reduction in furlough as employers got used to, I think, the new working arrangements. May was, I think, that we were in the eye of the storm very much. But as we kind of adjusted to it, more and more people came off furlough. But of course, the January figure coincides with the January lockdown, although I appreciate for some people there was an earlier local lockdown, but for the national lockdown, it kicked in January 2020. And that saw an increase in the use of the furlough scheme. I think that's going to be pretty consistent until lockdown measures are eased significantly. And how does the UK scheme compare? There was a lot of discussion around, I remember this time last year when we were trying to think about whether the government would introduce a scheme. And bearing in mind, the government has never introduced this sort of intervention in this massive way at all. So I think I was probably expecting perhaps a 60% contribution level, not the 80% that the government introduced. Put some stats up on there on other countries about what their government was paying in terms of wage costs. Always difficult to compare, I think, different jurisdictions, because the way that they define their scheme and calculate wage costs can be a little bit different. So, but it certainly shows that the UK has compared well with that scheme. And I think many employers out there have seen the value in it. And I think the big question now is, will the scheme be extended? Because it was originally meant to end way back in June 2020. And I think it's been extended at least 4 times since then. And it's now due to end on the 30th of April 2021. Now, what was supposed to replace it was the job support scheme and the job retention bonus. So in November, there was going to be a job support scheme, which effectively was a similar scheme to furlough, but it was less generous, and it was very much more focused on subsidising for unworked hours. And the job retention bonus was going to be a payment of £1,000 per furloughed employee who was still employed, I think, at the end of January 2021. And that was a payment again from the government. Now, I think the job support scheme, I think, has probably disappeared for good. There is the possibility they could introduce it at the end of April instead of extending the furlough scheme. My own view was that job support scheme was overly complicated, and I think wasn't that generous. And I think that was part of the reason why they had to extend the scheme. The job retention bonus, that £1,000, we may see come back at some stage. When the government decided they were going to postpone the job retention bonus, they did say they were going to look at some other incentives to introduce at a later stage. I've seen nothing as to what those incentives might be, but certainly there may be something in the future on that. But certainly I wouldn't bank on that sort of money being in the bank at any stage. The real concern, of course, is the extension beyond the end of April 2021. And this idea of the cliff edge, because if the scheme ends when effectively lockdown measures are still in place, there's, of course, a view that that could lead to mass unemployment. I've certainly seen some figures which have speculated that there could be 1 million jobs who are kind of just clinging on because of the furlough scheme. And I think the government desperately wants to avoid, understandably, that sort of mass unemployment. Key issues will be the virus vaccination rollout program and the lifting of the restrictions. I was hoping that the Chancellor would be giving us a bit more of an indication about the extension of the scheme. He was doing the rounds of the government of the politics programs on Sunday morning, and he was very keen to make clear that he wasn't going to pull the rug out from business, but wasn't actually giving anything really away in terms of the extension of the furlough scheme. I think he will extend it. I think he'll extend it to the end of June at the very least, because that's when really we're hoping we come out of effectively the national lockdown measures, when social distancing is removed, and hopefully many businesses are then potentially back in the office. Or I'll talk to you about whether I think that's going to be the case. But what we'll do certainly after the webinar is, once we know what the Chancellor's saying tomorrow, when we send our kind of update around with a copy of the recording, I'll just mention in there what he's done with the scheme. Remember, there's still some difficult issues, and probably the most important one to consider are the changes regarding furlough and notice pay. Some of you may remember that during the earlier furlough scheme, that if you made someone, say for example, redundant whilst they were on furlough, then effectively you could claim back 80% of those notice pay costs, as long as they were working their notice. It didn't happen if you made a payment in lieu of notice. But if you had an employee on furlough, made them redundant, gave them notice, had them work their notice, albeit on furlough, then you could recover some of that wage cost under the furlough scheme. Effectively, the government was subsidising notice pay costs. I was quite surprised that the government was doing that, but they've clamped down on that in the latest iteration of the furlough scheme, in that if you make someone redundant and they're still on furlough, then the employer has to pick up the cost of that notice pay in its entirety. You won't be able to recover that back under the furlough scheme. So do I think the furlough scheme is going to be extended? Yes, certainly that's all the mood music we're hearing from the Chancellor and the Treasury at the moment. But watch this space, or watch Rishi's speech tomorrow, and we'll have that confirmed. But as I say, I'll let you know as soon as I know. But let's not just get caught up in furlough, because I thought it'd be interesting just to touch on some of the other things that have landed in my inbox over the last month or so, as I think businesses are starting to consider other issues around coronavirus and employment law implications. First of all, don't forget the carryover of unused holiday entitlements. You may recall that the government actually changed the working time regulations, which before now haven't allowed the carryover of holiday. But they amended it so that employees have been unable to take holiday because of the impact of coronavirus. Remember, that's not just because they've had coronavirus. That could be because the work was such that they weren't able to take holiday at a particular time. You can now carry over maximum 4 weeks holiday into the next 2 years. And what I'm already seeing now is employers having to look at quite carefully the amount of holiday that employees have accrued but not been taken in the last holiday year, because potentially that's a huge amount of holiday that's going to be carried over that employees understandably are going to want to take. So I think if you're an employer, one of the things to look at now is look at your holiday years, look at what holiday hasn't been taken, look at the reasons for that, and work out what sort of levels of accrued holiday are going to be carried over, and then start on kind of managing employees' expectations about when they can take that, because not everyone's going to be able to take that holiday as soon as possible. Although I've seen plenty of requests going in for holiday on the 21st and 22nd of June, understandably. So that's dealing with the carryover unused holiday. Hybrid working is certainly one of the top items on the HR agenda. I had conversations with people last week about this idea of a 3-2 or a 2-3 split. And looking at that, that's the extent to which you're going to require employees to be in the office, so 2 days a week or 3 days a week, or working from home. And certainly, I think employers are going to have to think about this carefully. I did read with interest the comments from the boss of Goldman Sachs, who was saying that he regarded home working as an aberration, and effectively, as soon as they can, everyone was going to be required to come back to work. I'm not so sure that's going to apply for many employers who've, almost en masse have implemented a home working regime. And I'm not quite sure everyone's going to turn around at the end of June and say, right, everyone back to work. And employees aren't necessarily going to want to go back to work full time. And I think employers, again, if you're adding onto your to-do list, it's looking at how you're going to make that work. Are you going to require a big bang and everyone to return? Or are you going to do it more gradually? Or are you actually going to acknowledge that this is a new way of working, and we're actually going to split between home and office-based, with offices having a more collaborative hub feel than, say, a destination 5 days a week? Be aware of collective redundancy consultation. And the reason why I say that is that back in March 2020, when employers were looking at, even with the furlough scheme, having to make some significant redundancies, particularly 20+ redundancies in a period of 90 days or less, collective redundancy consultation was triggered. What we found, though, was just simply because of the impact and the timescales we were a bit involved in, that actually it was almost impossible to follow the required procedure and timescales. That's not something you're going to be able to get away with as an employer at the moment. So if you are now contemplating making significant redundancies as we come out of lockdown because of the impact that it's had on your business, you are going to have to build in collective redundancy consultation. And that's going to be consultation with employee representatives. That could mean having to build into your timescales election of employee representatives. Normally, I would factor in about a kind of 2-week timescale for election and balloting if required. So if you add that onto a 30 or 45-day consultation period, that can actually extend quite significantly the consultation process. Compulsory testing and vaccination is the buzz at the moment amongst HR and employment lawyers. I'm not going to contribute to the massive amount of articles out there as to whether compulsory testing and vaccination is lawful. I think it will be a measured approach. I think for some businesses, perhaps in the care sector, health sector, you'll be able to effectively impose, particularly on new employees, a requirement they've been vaccinated before they take up employment. But that'll only be the case, I think, as the vaccination program's rolled out. For many other employers who are looking at compulsory testing and vaccination, I think you have to ask yourself the question as to, why do you need to make it compulsory? What is that's going to give you beyond your current social distancing and other protective measures that you don't get at the moment? And I think for many employers, when they look at that, I think whilst vaccination testing will be strongly encouraged, I'd still be surprised if we see a huge swing towards compulsory vaccinations particularly. Thought as well I'd just touch on the impact on the employment tribunals as well in a number of ways. Certainly we're starting to see some fascinating cases come through. Hopefully some of you saw the face mask case that came through last week. It was really the first, say, coronavirus case that the employment tribunal at first instance had decided. I think it was in Kent, the tribunal. And this was all to do with an employee attending a client site who refused to wear a face mask and was then dismissed by his employer. The tribunal held that that was a perfectly fair dismissal. It was a refusal to obey a lawful order. They followed the right process, and that was fair. But we're going to start seeing more and more of these cases coming through. Also starting to see far more interim relief cases coming through. I can remember, I think in my career up until now, I've only probably ever done a couple of interim relief cases around trade union membership. An interim relief is a sanction from the employment tribunal where an employee who's been dismissed can apply effectively to certain dismissals to effectively put their dismissal on hold and continue to be paid. Now, we've started to see more and more of those interim relief cases, particularly on the back of health and safety claims and health and safety dismissals. So more and more having to deal with that. And if you're an employer faced with an interim relief claim, it is difficult, and there is a real need to move quickly on that. So if you ever get one of those in, you need to take advice urgently on that, because the timescales are tight. And interim relief is probably going to be extended as well. There's a case it's currently going through appeal, which has said the government hasn't implemented the Equality Directive correctly, because it doesn't allow for interim relief in, say, discrimination claims. So if that goes through, then potentially we'll see interim relief being extended out. Gender pay gap reporting, just mention on employment tribunals as well, is the other major impact is that the tribunal system is creaking, and certainly in some offices seems rather broken. The tribunal system was already under considerable strain prior to the pandemic, but like any other business, when we went into lockdown, effectively the tribunal offices shut. People weren't going into them, and there was a kind of 3-month period where no tribunal claims were taking place at all, no tribunal hearings. And what we're seeing now is the fact that we've had a delay in the cases that were in the system, also mixed in with a massive influx of cases, say on interim relief or unfair dismissal or failure to pay holiday pay correctly while someone's been furloughed. All of those things are leading to a massive delay in dealing with tribunal claims. And we're starting to see some quite tough timescales imposed on particularly employees who are potentially having to wait, almost upwards of 2 years to get in their claim heard. There is more resource being poured into the tribunal as we speak, but there is still a considerable delay. And what that means sometimes for employers, I had a conversation with my clients the other day where we were outside of the 3-month time limit for bringing a claim. We're outside the ACAS time limit for bringing a claim. But I did say there was a note of caution, because the claim could just be sitting in the employment tribunal waiting to be processed alongside everything else. So I'm sure there's still some nasty surprises to come through the door for some employers, unfortunately. Lastly, I just wanted to touch on gender pay gap reporting. The Equality and Human Rights Commission have effectively delayed enforcement action for gender pay gap reporting until 4 October 2021. It was postponed or cancelled for 2020. I think there was a big concern that it was going to be cancelled again. And what they've effectively done is postponed compliance by 6 months. So if you do fall within gender pay gap reporting, you do have a little bit more time. I think that's helpful, because furlough and things like that, I do think, complicate those calculations, but definitely worth thinking about as we go to there. So appreciate that's a whistle-stop tour through coronavirus and all other considerations. What I'm going to do now is hand over to Lindsay, who's going to take us through a couple of important case law updates. So over to Lindsay.
Thanks, Matt. Well, good morning, everybody. So now we've got our case law update for you this morning. I hope that everybody can see that screen correctly. We've got several important and interesting cases that have come through over the last few months, including an update on TUPE and the splitting up of employment contracts, a case that's been going on for quite a long time on the limits of vicarious liability, a new and interesting case about discrimination and gender fluid employees, and an update on the extension of health and safety protection for workers, a new case on equality training and harassment, and of course the long-awaited Supreme Court decision on the Uber drivers. So kicking off with everybody's favourite subject, TUPE. This was a European Court of Justice case which asked the question, can a contract of employment be divided between transferees following a TUPE transfer? Now, this was the case of Mrs. Govertz, who was employed by ISS, and they were responsible for cleaning and maintenance of various buildings in Ghent in Belgium. And the work was divided into 3 lots in relation to different buildings. Mrs. Govertz was project manager, and she covered work on those lots, and she spent 85% of her time on lots 1 and 3 and the rest on lot 2. ISS was unsuccessful when they re-tendered for this work, and they lost lots 1 and 3 to Italian, and the remaining lot 2 was awarded to a contractor called Cleaning Masters. Now, ISS told her that she would be transferring to Italian under TUPE because most of her work was spent on lots 1 and 3. Italian didn't agree that TUPE applied, and so they terminated her employment, and she brought claims against both ISS and Italian. Now, the ECJ held that where a transfer of an undertaking involves more than one transfer, which it did in this case, that the rights and obligations arising from the contract of employment will transfer to each of the transferees in the proportion to each task performed. So that could result then in the splitting up of a full-time contract into several part-time contracts. And the ECJ held that it would be up to the National Court to decide how to divide those contracts, taking into account consideration of the economic value of the lot to which the worker is assigned. The ECJ also held, which is rather interesting, that if a division of the contract is impossible or it adversely affects the rights of the worker, then the transferees will be responsible for any consequent termination, even if the employee resigns. So, what does this mean for employers? Well, under current UK case law, as you may already know, if there's a transfer of a business or service and it splits up into parts, then normally what we look at is the percentage of time, amongst other things, the percentage of time that the employee actually spends working on that part of the business. And we usually look at, if it's more than 50%, then that's the bit that they will transfer with. So this could result in some difficult decisions relating to specific facts of the transfer, particularly when it's the transferees who are going to be responsible for any consequent termination, even if the employee resigns. So the transferees would be liable for any notice payments, any unfair dismissal claims, and any potential redundancy costs. So our advice in this situation would be, if you're going through this and you're buying a business or you're taking over the provision of a service that's been split up, then you should make sure in your contract with the seller or the outgoing provider that you are protected against any of the liabilities that might transfer under these circumstances. Okay, so now we're going to go on to a case that you've probably all heard of already. This was the case of Morrison's Supermarkets. They had a formal internal auditor called Andrew Skelton who leaked payroll data of thousands of employees to the press. This was because he was aggrieved and peeved because Morrison's had taken some disciplinary action against him some months earlier and he was out to get them. And this resulted in a civil claim of over 5,000 employees. And they wanted compensation for loss, for distress, for loss, of potential identity theft and other personal loss. Now, there were two key questions before the court. Was Morrison's directly liable for the breach under the Data Protection Act or at common law? And should Morrison's be vicariously liable for the actions of its ex-employee? Now, the court said there was no primary liability, but there was vicarious liability. In common law, an employer is vicariously liable for the wrongful acts of its employee if the acts are done or carried out in the course of that employee's employment. And the court said, on the facts, the disclosure of the data was sufficiently connected to Skelton's employment. And the issue was therefore not whether Morrison's had acted wrongly, but whether when Skelton did so, his acts were closely connected with his employment. Now, although Morrison's were the main target of his actions and his wrongdoing, the court held that it was just and fair that Morrison's should be vicariously liable for the wrongful acts and the loss to the affected employees or data subjects. Now, the Court of Appeal upheld this, but the Supreme Court disagreed. The Supreme Court decided that Skelton was not engaged in furthering his employer's business when he committed the wrongdoing. On the contrary, they said he was pursuing a personal vendetta. He was seeking vengeance for his disciplinary proceedings some months earlier. And Skelton's misconduct was not so closely connected with acts that he was authorised to do. So for the purposes of the third-party liability to the employees, it couldn't be fairly and properly regarded that he was doing these wrongful acts in the course of his employment. So overall, this ruling should be a comfort to employers and insurers. It does keep in check the potential liabilities that can be transferred to the insurer, but at the same time, it is a stern reminder for everybody, for us, for you as employers. All organisations must make sure that they have their data protection policies and cybersecurity policies robust and up to date. Organisations can, of course, insure these liabilities, and this case obviously highlights the importance of that. And this case does really narrow the scope somewhat when it comes to the actions of rogue employees such as Andrew Skelton, and it does call into question a little bit the suggestion that passing on the liability to the employer is somehow more easily done just because they've got those liabilities insured. Now we're moving on to a very important case against Jaguar Land Rover, which resulted in the unanimous decision of the Employment Tribunal in Birmingham, ruling that the protected characteristic of gender reassignment includes gender fluid and non-binary employees. Now, this is a really interesting case, and if you get the chance to read the judgment, then I would say do, because it was very interesting to read. Gender reassignment is a protected characteristic under the Equality Act alongside race, sex, religion, etc. And in this case, the claimant was a long-standing employee. She had 20 years service. And in 2017, she identified as gender fluid non-binary, and she started dressing in women's clothes, whereas previously she'd identified as a man. Subsequently, she was subjected to a lot of abuse at work, insults and abusive jokes. She also suffered difficulties using the toilet facilities and a lack of managerial support. So she brought claims of constructive dismissal, harassment, direct discrimination, and victimisation on the grounds of gender reassignment. Now, JLR argued that Ms. Taylor, because she was gender fluid and non-binary, did not fall within the definition of gender reassignment under Section 7 of the Equality Act. So the judgment in this case, the judge, as I say, the judgment was unanimous. The judge upheld all of Ms. Taylor's claims, and during submissions, there was a reference to the original the comments made during the original Equality Bill debates in Parliament, when the Solicitor General had said that gender is a spectrum and that gender reassignment concerns a personal journey and a moving of the gender identity away from birth sex. And the tribunal held that it was clear that gender is a spectrum and that it was beyond any doubt that the claimant fell within the definition of Section 7 of the Equality Act. Now, the implication from this judgment is that other complex gender identities may also fall within that definition of gender reassignment under Section 7 of the Equality Act, where individuals are proposing to undergo a process of moving their gender identity away from birth sex. So if you read the judgment in this case, it's clear that Ms. Taylor did suffer some extremely abusive behaviour from work colleagues, and the judge said that perhaps what was most shocking is JLR's failure to deal with it properly. The management team was out of their depth, and there was a lack of support from HR, even after several very serious complaints from Ms. Taylor. So there were some bad examples in this case. The judge commented on it and awarded aggravated damages to Ms. Taylor. And this was particularly given the size and resources of the employer because they were such a big employer. Now, this is a tribunal case, an employment tribunal case, so it's not actually binding on other courts and tribunals, but I think it is likely to be very persuasive in other future cases of this kind. You don't really get to see a lot of gender reassignment cases. They're actually quite rare, but our advice to you as an employer would be to review your policies and procedures, check that they're all compliant under this wider definition of Section 7 of the Equality Act, make sure that staff are trained on gender identity awareness, and at the very least, if you get any complaints about this subject, please take them seriously and contact us for advice. Okay, so now we've got a trade union case for you. This is the Independent Workers Union of Great Britain, and they have around 5,000 members who are principally low-paid workers in the gig economy. Now, These members raised concerns about not being given the necessary PPE to protect them at work, and that they also ran the risk of having their engagements suspended or terminated if they took steps to protect themselves by stopping work when they felt that they were faced with serious and imminent danger in the workplace. Now, this was due to COVID-19, being exposed to COVID-19 at work, with there being a lack of PPE available, a failure by the employer to implement social distancing during deliveries, a lack of provision of sanitizing and cleaning products, and the failure to package COVID-19 samples properly, for example, for those drivers that were collecting COVID-19 samples. Now, employees in the UK have a raft of health and safety protections, mainly derived from EU law, including the right to stop work when faced with serious and imminent danger. And they benefit from an obligation on their employers to provide them with the necessary PPE at work. So the union in this case brought a judicial review, seeking declarations from that the UK had failed to properly transpose into domestic law these two EU directives. And they required that these directives require member states to confer health and safety protection on workers, whereas the UK legislation only actually protects employees. So the Department for Work and Pensions and the Department for Business, Energy and Industrial Strategy argued that the EU's definition of work only extends to those employees who are employed under an employment contract by an employer. That has properly been transposed into domestic law. And they also said that there are other forms of protection in the UK for workers who are not employees, and they meet the EU's minimum standards, even if they're not identical. So after an exhaustive review of the relevant EU legislation and case law, the High Court ruled in favour of the government on one of the union's claims, and it found that the EU law had imposed a duty on employers to ensure health and safety of their workers in every aspect of their work, and that had been reflected into domestic law. However, the High Court found against the government on the rest of the claim, which focused on the rights of workers to refuse to work if they perceived danger and the use of PPE, and that these rights should be extended to all workers. Now, this is an important judgment because it extends health and safety protection to all workers and not just employees, including those in the gig economy who, let's face it, many of us have been very reliant on during the pandemic, delivery drivers and so on. So if you have anybody working for you who's not an employee, could be categorised as a worker, and this can often include people on self-employed contracts, then you must remember that you have a duty to ensure their health and safety in the same way as employees. Okay, so now we have a case about harassment and equality training, which was the case of Ale and Gellen, and this was the question to the court. Can an employer rely on the reasonable steps defence to harassment when it has provided training to staff? Now, as you may already know, under the Equality Act, employers can be held responsible for harassment committed by their employees, regardless of whether they approved it or even if they actually knew about it. However, the Equality Act also provides a statutory defence for employers, which provides that they can avoid liability for discrimination or discriminatory acts of their employees, where they can establish that they took all reasonable steps to prevent the offending employee from doing the acts in question. And this is known as the all reasonable steps defence. So the claimant in this case was subject to racial harassment and racist comments at work on a regular basis by another colleague. Two managers were aware of the racist comments, but they took no action whatsoever, apart from to issue a very minor reprimand, and they didn't report the incidents at all. The perpetrators and the managers had all had anti-harassment training from the employer in the 2 years preceding these incidents. And the claimant brought a claim for harassment on the grounds of race, and the employer sought to rely on the all reasonable steps defence. And the EAT upheld the tribunal's decision that the employer couldn't defend a claim relating to the alleged discriminatory actions of its employees, where it had failed to prevent its training from becoming stale and ineffective. So if your training isn't up to date, if it's just going through the motions training and it's stale and ineffective, then that's just not going to cut it if you have a claim against you in a tribunal. And the EAT said it's not sufficient for an employer just to simply show that it's got policies and procedures in place, like equality and diversity or equal opportunities policy. And even if it provides training, the EAT said it must show that it's providing its employees with the effective materials to prevent discrimination, bullying and harassment in the workplace, and that it subsequently has taken any steps necessary to make sure that training is actually having a continued impact on employees. So as an employer, you must really consider the frequency and the quality of the training that you are provided to ensure that you can be seen as taking all reasonable steps, subsequently increasing the likelihood that you will be able to rely on that defence if you ever have any claims against you. So updated and regular training on equality and diversity is a must. So please contact us if you would like to arrange for any training, refresher training for staff. Okay, so now we're moving on to the final case today, which is the long-awaited Supreme Court decision on Uber. So this is another case that's been going on for a couple of years, and the Supreme Court has upheld the earlier court's decision that drivers working for Uber were workers and not self-employed contractors. And this decision is important for employers because it highlights the fact that the courts will scrutinise the reality of any relationship, regardless of contractual labels. So as most people know, Uber operates a smartphone app by which customers order their taxis and make payments for their journeys. So Uber's position in this case was that it merely facilitates provision of these services via the app, and that it was acting as the driver's agent. But the contract was actually between the driver and the passenger for each journey. The tribunal said that the suggestion that Uber was acting for 30,000 small businesses was frankly ridiculous. And they found that actually Uber was exercising a very high degree of control over those drivers in a number of ways, which meant that they couldn't be viewed as genuinely self-employed. So the tribunal found that the correct position was that Uber contracted with the passengers and engaged the drivers to carry out those bookings, and that whilst the drivers may have been free to decide when and where they worked, once they were working, they were workers. And the court highlighted several key aspects of the relationship that made them workers, one of which was the fact that the remuneration was dictated by Uber. Uber also set the fares. Uber imposed contractual terms on the drivers, and the court noted that there was actually no practical possibility of the drivers negotiating any other terms to that relationship. The court also decided that once logged onto the Uber app, the driver's freedom to accept fares was constrained, and Uber controlled all the passenger information provided to the drivers, and they also monitored the drivers' acceptance of fares. They penalised drivers for not accepting fares, and they kicked them off the app automatically. And the court said that this placed the drivers in a subordinate position to Uber. The court said that because Uber owned and controlled the technology, which was at the heart of the app, that this essentially gave significant control over how the drivers delivered their services. So what does this slide mean? What does this mean for employers? Well, it doesn't mean that the contractual documentation that you've got in place is worthless or irrelevant. It will be a relevant factor, of course it will, but it is the conduct of the parties in reality that the court would look at. And in this case, realistically, if you engage self-employed contractors, you should really audit how it works in practice, not just rely on what's written in the contract. And if it looks like you've got a worker contract, then you should treat the worker as such. Or if you need to, you adjust the way the relationship works to move in practice. So then you can move it over to looking more like a genuine self-employed, genuine contractor relationship. Okay, so I'm going to hand back to Matt now.
Thank you, Lindsay. That was really interesting, and I read with interest that Uber decision. I thought it was quite a radical decision from the court. If you read the full case decision, it's certainly more radical than I think we thought we were going to get from the Supreme Court. And it certainly wasn't just, I don't think, rubber stamping the decisions that had previously been made. I do think there's some important stuff in there. So thank you for that, Lindsay. I'm now going to attempt to share my screen again. This is where it could all go horribly wrong. So bear with me. And I will just apologies for the whistle stop tour through Lindsay's slides again. So employment law 2021 and beyond. And as I said in the introduction, the reason why we wanted to have a look at this is because I think we forget that employment law has been continuing at a pace, even with the pandemic, and perhaps not as much as we would have expected, but there's certainly some things that are coming up in the short term and perhaps the longer term that I do think are going to have an impact for employers. And I think Lindsay's going to kickstart us off on our journey into employment law 2021 and beyond, by talking about Brexit, because at last we know a little bit more of what Brexit may mean for employment law in the UK. Lindsay.
Thanks, Matt. Okay, let's go back to my screen now. Here we go. Right, employment law and beyond Brexit. Okay, so there has been widespread speculation ever since Brexit that the government want to review employment law rights, shall we say, or even take some rights away. However, in a recent ITV interview, the business secretary said the review is no longer happening. He said, I made it very, very clear to officials in the department that we are not interested in watering down workers' rights. I've said repeatedly that Brexit gives us the opportunity to have higher standards and higher growth economy, and that's what officials in the department are 100% focused on. Now, there was speculation that the government was planning to scrap the cap on the 48-hour working week, to change the way that holiday pay is calculated, and to change the rules around rest breaks. So currently, employers are obliged to include overtime commission and bonus payments when calculating holiday pay. However, it was being claimed that any overhaul would mean that these elements are no longer included in any pay calculation. So currently, as it stands, existing EU-based employment law shouldn't change in the UK post-Brexit unless the government legislates to change it, which of course they are free to do and is what is being speculated. In addition to any legislative changes that the government might make going forward, British workers will no longer have the benefit of judgments of the European Court of Justice. UK courts will still be able to have regard to any decisions coming out of the ECJ concerning worker rights, but they will no longer be bound by its decisions. So from an employer's perspective, this could be a blessing because it will mean less time having to adjust working practices to any new EU law that's coming out of the ECJ. And ever since the UK has voted to leave, we've had speculation about how UK employment laws might change, and those have obviously gathered pace recently in light of the post-Brexit trade deal that we've got now. Much of our employment law here is derived from the EU, including the rules on working time, TUPE, which protects employees' terms and conditions of employment when businesses are bought and sold, and discrimination rights. And experts have warned that post-Brexit, employees might lose their protection under TUPE. So employers would be able to make changes to contracts of employment for better or for worse. Another possible target area could be discrimination rights, and tribunals could start to cap the amounts awarded in discrimination cases, as they currently do in unfair dismissal cases. There's currently a cap in tribunal on awards up to, it's about £88,000 currently. So we could start to see this in discrimination cases, and then we won't see the likes of awards that we've seen sort of for bankers in sex discrimination cases, awards of up to £4 million, for example, that could be capped. So if the government did decide to abolish the 48-hour working week limit, then this might affect its international competitiveness, which might cause problems with the EU in light of this post-Brexit trade deal that we've now got. And as I say, the Business Secretary has said that the government wants to work to enhance worker rights and not to erode them. So it remains to be seen whether or not that will happen. So watch this space. And I'm going to hand back to Matt.
Thank you, Lindsay, for that. Just while we're on Brexit, because I did see we have, and I know I said I'd take questions at the end, but I thought this was probably a good time just to take a question on this, because really interesting question is, does the ECJ decision on splitting roles, which Lindsay was talking about, relevant in the UK post-Brexit? And I think the answer to that is yes, because that ECJ case will still be binding on the UK courts unless they want to try and depart from it. I think it's quite a difficult decision to implement anyway, but I still think those will have standing. It's cases kind of post-Brexit, which I think we're not going to be bound by, although we can take account of. So I think that's a good question, but yes, I still think those cases, and certainly some more EU cases we've seen in the last year, are still going to be relevant. So let me just go back to sharing my screen. There we go.
I think you might be on mute, Matt.
Apologies for that. I managed to mute myself. I knew I would at some stage today. Let's just go back. The long. There we go. The long-awaited employment bill. Thank you, Lindsay. Hopefully everyone can hear me now. This was announced back in December 2019. I think it was part of almost the Brexit strategy, because I think the government was coming under pressure then to deal with the concern that Brexit was going to see a bonfire of employment rights. And so part of the strategy for that was this employment bill they announced back in December 2019. It was much trumpeted. There's various bits and pieces in there, and I'll just pick out a couple of highlights. First of all, this right to request a more predictable and stable working pattern, very much aimed at the casual 0-hour gig economy. But as with all right to request, and of course, remember the right to request flexible working, it's a right to request rather than an absolute right for predictable and stable working patterns. But it's certainly something that I think people were waiting with interest. Probably the one that got the most publicity was extending redundancy protection for those returning from maternity leave. Some of you may recall that employees who are on maternity leave do have an enhanced protection when it comes to redundancy, in that if they are made redundant whilst they're on maternity leave, they effectively have a preferential right to any suitable alternative employment. And that's offered to them first, beyond anyone else who may be at risk of redundancy at the same time. There's a concern that that's being used quite cynically by some employers, so who are waiting for an employee to return from maternity leave before they make that decision, or making a redundancy decision before someone goes on maternity leave, so that that preferential right doesn't apply. Now, the idea is that's going to be extended, so it will apply from the moment someone informs their employer that they're pregnant, and for a period of 6 months after they return from maternity leave. There's a lot to unpack in that employment bill. Some of it will have a major impact, some of it not so much. I think the concern at the moment is that at the moment there is just no visibility as to when that's going to find some parliamentary time to get onto the statute books. I saw something that said, well, we might find some time at the end of this year, but time's ticking. I think it's going to be more like 2022 before we see anything like those provisions coming into place in the long-awaited employment bill. Next, just to have a look at is the consultation on reform of non-competes. I can see that I've got some clients who I know and contacts who are on the webinar who will probably be dreading this bit, because there's an opportunity for me to get on my post-termination restriction anorak, because I do like a good post-termination restriction issue. The government is now consulting on the reform of non-compete clauses. Now, this consultation is about those clauses in contracts of employment that stop an employee from going to work for a competitor once their employment has ended. They're not looking at making any changes to things like non-solicitation of client clauses, non-dealing with client clauses, and also not making any changes to confidential information. We're talking here just about that pure non-compete clause. It's a reaction to the pandemic in some ways, also a reaction to Brexit. It's an idea that we need to make the UK more competitive and entrepreneurial. And I think that has a place, and they're looking at how they then reform non-competes to allow for that. So one idea is that you require employers to pay compensation for the duration of the restriction. And that's certainly a European approach. There are some European countries where you have to pay a percentage of the former employee's salary for the duration of the non-compete. So there's the idea that that could be one way of keeping non-competes enforceable. And making sure non-compete terms are confirmed to employees at the outset, I think would be sensible. And this is to avoid the issue of employees suddenly being given a contract of employment just before their employment's about to start, which has got lots of restrictions in there. The employee really doesn't have freedom of choice there. There's a statutory limit on length of non-compete that's also being consulted on. So the idea that how long should a non-compete last for? And that really is how long's a piece of string. I think in the current climate, a non-compete clause, certainly anything over 12 months is probably unenforceable, but certainly 6 to 12 months is probably around the sweet spot at the moment for that. The nuclear option, though, they're talking about is banning the use of non-compete clauses altogether. And this seems to be influenced particularly by the experience in California. And for those who may know, but I appreciate plenty don't, California actually has a complete ban on non-compete clauses. And what the government has seen is they think there is a link between the entrepreneurial spirit in California, particularly Silicon Valley, and their ban on the use of non-compete clauses. And they think that if we were to ban non-compete clauses in the UK, that perhaps we would generate some similar entrepreneurial spirit. Now, it's a consultation paper at the moment. Those of you with good memories may remember that the government previously consulted on reform of non-compete clauses. I actually sat again for my sins on the Employment Lawyers Association working party that responded those few years ago to that paper, and it got kind of pushed into the long grass, really. I think this is a much more focused consultation paper, and I really do think that we may see some significant changes to the use of non-compete clauses in contracts of employment. That doesn't mean if you're drafting contracts of employment that you shouldn't include them at the moment, but certainly I think it's something to take account of when you are looking at drafting, is that they may change in the not foreseeable future. So definitely something to have a look at. A quick mention, increase to national minimum wage, that's happening in April. So those rates are going up. And of course, April will see increases to things like statutory maternity pay, statutory sick pay, etc. We are producing a kind of fact sheet, which will have all those increases on it. We're actually waiting for the government to confirm whether they're going to increase the cap on a week's pay for redundancy pay calculations, and also the limit on compensation claims for unfair dismissal. And once that's done, what I'll do is I'll make sure everyone who registered for the webinar gets an up-to-date fact sheet, so you've got that all to hand. But I wanted to mention that the national minimum wage was increasing. Employment status, the wait goes on. Goodness me, how long have I been talking about the Taylor Review and the Good Work Plan? It seems like years, because it has been years, frankly. And in response to the Taylor Review, back in 2018, was it, the government introduced the Good Work Plan, which is their response to the Taylor Review. And they said they were going to legislate to improve the clarity of the employment status test. And this was all to do with the new way of working in the gig economy. And they've acknowledged that they need to legislate, but they haven't actually done anything about it. What they have done is commission some further research into how they could improve the clarity of the employment status test. Well, that response is still awaited. And I think most employment lawyers and HR practitioners would welcome some clarity on the employment status test, because at the moment, and in the absence of any statutory intervention, case law continues. Lindsay gave a brilliant explanation about the Uber case, which, as I say, I think is quite radical. But whilst the government waits, there are some cases right at the cutting edge. You know, we've had Jess Varnish, haven't we, bringing unsuccessfully her claim against British Cycling that she was actually an employee. We've had a successful claim in the Scottish tribunal system that foster carers are in fact employees. We've also had some challenges from the Independent Workers of Great Britain Union against the CAC about de facto employment status, although I did see last week they've lost the latest round in their appeal on that. And I think what it does show is that if the government isn't prepared to legislate, then people are still going to bring claims around employment status, worker status, and it will be up to the courts to make that decision. And whilst the Uber decision will be helpful, certainly there are organisations who are prepared to push the envelope, certainly as to what employment status might mean. And lastly, mentioning IR35 and off-payroll working, just to try and bring some clarity to this. And I appreciate I could probably spend, again, a day trying to explain IR35, but its purpose, individuals who are working like employees, but who operate via an intermediary, often through their own personal service company, should be paying the same tax and national insurance contributions as an employee would. Now, IR35, believe it or not, was introduced way back in 2000. I just don't think it's been policed that well by HMRC. Public sector changes were introduced in April 2017. The private sector changes were due in April 2020. Of course, that coincided with largely the pandemic effect and lockdown, and that was postponed, but they are now coming into force in April 2021. I've seen plenty of speculation that they may be postponed again, but everything I'm reading at the moment is they are going to be introduced. What the government is going to do is perhaps hold back on some enforcement issues for the first year or so, but nothing I've read says expect a further postponement of IR35 changes beyond April 2021. And what does it mean? Well, if you're the end user client and you're using a consultant, for example, who supplies their services, so you engage Joanna Blogs, and Joanna Blogs provides their services through Joanna Blogs Limited, then you as the end user, you're the client, you carry out a status determination, and you have to determine whether or not that relationship is one that falls inside or outside of IR35. And effectively, it's a determination to say, but for their personal service company sitting in the middle of the relationship, would it in effect be an employment relationship? Now, you've got to pass that status determination down the chain when you've made that determination. And if you're inside IR35 as a fee payer, you're responsible for the tax and national insurance contribution deductions before you pay the intermediary. So before you pay Joanna Blogs Limited, you have to deduct the tax and NI from that and pass it on to her service company net. And liability for tax can be passed back up the chain. So the example I've given is a very simplistic one, but you can have a multi-chain use of consultants where various agencies are involved, and effectively the consequence for not paying the tax get passed up the chain ultimately to the end user client. Such that for the first time, if you're the end user of a client, you're the end user client, IR35 is going to have an impact. There is a small employer exemption, so please don't ignore that. But many employers are finding that they're fully fair square in this regime now. And making the determination that the government has, via HMRC, issued the CEST tool. It's helpful, but flawed, I think, in a number of ways. But I think that's where most employers, most companies who are end users are turning to make that determination. But it is important. I know lots of clients of mine have done plenty of work on IR35, and I suspect hopefully those plans are being dusted off or have been dusted off, given the changes that are going to come in April 2021. So that's just a mention on IR35. That does bring us to the end, but I did say hopefully we would have time for some questions. So let me have a look at what we've had in as we go along, and Lindsay and I can jump on and answer them as well. So the first one, are employers within their rights to set a carryover of days and pay employees for days not taken by then end of the firm's holiday year? Well, absent the changes to carryover of holiday and coronavirus, and also ignoring some of the statutory protections, so employees who are unable to take holiday because of sickness, absence or maternity leave can still carry over untaken holiday, then yes, as an employer, you can either say you can't carry over at all, or you can only carry over a certain number of days and they have to be taken by a certain period. But so far as the coronavirus amendment is concerned, those sort of clauses can't apply, is that employees can carry over a maximum of 4 weeks into the next 2 holiday years, even if you haven't provided for it. Lindsay, perhaps one for you to we can have a think about a question here about, do we think flexible furlough will continue beyond June? What do you think?
Who knows? I think if Boris's steps go to plan, then hopefully we'll start to see everything getting a lot better by then, if the vaccination goes to plan and businesses start opening up. But maybe they'll flex it a little bit more, but they won't give as much out, and there'll be more responsibility on the employer.
I agree. I think we might see it. I think we might see flexible furlough extended to certain sectors, so hospitality and leisure being one of them, as they kind of adjust to the removal of lockdown restrictions. But I think it'll only be for a short period of time. When we saw that cost, I think you can see how much it's actually going to take to work through that. A question here about, when did we stop being able to claim furlough payments for notice periods? I forget the exact date, but it was mid-December, I think, 2020, they changed the rules. And they did it in quite a sneaky way, in that they initially said, well, this is what we think is going to be the position. Then about 2 days later, they said, no, now that is going to be the actual position. So if you're making employees redundant, you can't claim their notice pay under the furlough scheme. Let me just make sure we've still got time for a couple of others. Pick out a couple of there's some. Someone's asked, is it obligatory to have anti-harassment training, or is it recommended only? Going back, I think, Lindsay, to the Galen case. What would you say on that?
I would say I would recommend it, because obviously it's going to give you it's going to give any employer an extra defence if they ever have a claim against them in tribunal. So I would say, obviously, to anybody, any employer, make sure your policies and procedures are in place, but it's not just there for the sake of having it, so that you can just share, oh yeah, we've got policies. Make sure the employees have them, that they understand them. And yes, I would always recommend training to make sure that people understand it, really, because I think what happened in that case, and also in the gender fluid case that I mentioned as well earlier, the Rose Taylor case, what was really clear with that is that the employees just didn't understand. They just didn't understand it. They just didn't know that wasn't acceptable to behave like that. And I think that does happen a lot in discrimination and harassment cases. So it just opens up the communication and gets people in that mindset of equality, diversity, and equal opportunities.
I agree. I think on a pragmatic basis, while it's not obligatory, if you don't provide anti-harassment, equal opportunities, diversity and inclusion training, and keep that refreshed, then your ability to rely on the reasonable steps defence in defending a discrimination claim is almost going to be taken away from you without that sort of training in place. A question around TUPE, so I'll get my TUPE anorak on at this stage. Does TUPE apply to a transfer of shares in a company? No, TUPE doesn't apply to a transfer of shares. It would only apply in two circumstances. One, when there's a business transfer, so a transfer of a going concern. But again, you don't want to disappear down that rabbit hole on this occasion as to what that may mean, or when there's a service provision change, but it won't apply to a mere share sale. Someone's asked the question about IL-35, about the rules don't apply to small businesses. Yes, the new off-payroll working in the private sector rules don't apply to small businesses. There's a small business exemption in there. It's quite a complicated definition of what a small business, so worth having a look at. And certainly if you're thinking you're going to be caught by IL-35, probably the starting point is to work out which regime you fall into, and see if you're exempt. Interesting question about where do I see the opportunity for the UK to potentially diverge from current and future EU law? Oh, that's a controversial one, isn't it? I think Lindsay mentioned some, didn't she? So I don't think, from my own perspective, they would abolish the transfer of undertaking regulations completely. Bearing in mind, we've already gold-plated those regulations beyond what the EU require anyway. I'm not sure that would follow. We would then want to abolish them. But I think certainly I could see being easier to vary terms and conditions, particularly to harmonise terms and conditions as a result of a TUPE transfer. I think we might see some changes to discrimination awards to try and bring them into line with unfair dismissal awards, as Lindsay mentions. And also, I think working time, I think if they could clarify and kind of go back to the old position on holiday pay, so it was calculated by reference to basic salary only, then I think they would love to do that. What do you think, Lindsay?
Yeah, I think so too with the holiday pay, because most employers don't pay it by reference to, by calculating using the commission and bonus anyway. We see that all the time. And I think with the TUPE, being able to harmonise T's and C's after a business sale or purchase, yes, I think we always get asked about that, don't we, when we have clients who are buying businesses. How soon can they change terms and conditions after they've bought the business? So I think certainly that would be ideal for a lot of business owners to be able to have that flexibility. So yeah, I can imagine that happening.
Yeah, no, I agree. I think there's some tweaks. I don't think we'll, as I say, see a wholesale kind of bonfire of EU employment regulation, but I think when the dust settles, we will see some tweaks to that. Question here asked about carryover of holiday again. So if an employee leaves, are they entitled to have that carryover of holiday of up to 4 weeks paid in lieu? Well, I think they would, because that will be carried over and it will count towards their holiday entitlement. And if they don't take it, then they would be paid in lieu in respect of it, in the same way that anyone on exit would get paid in lieu of holiday accrued but not taken. I think that will include any amount of the 4 weeks that's carried over. Do you agree with that, Lindsay?
Yeah, I would think so too. Yeah.
Yeah, I haven't seen anything that says that they've amended the regulations to say that doesn't apply.
No, me neither.
Interesting question on when offices can return to work, and will there be any obligation to undertake workplace testing? As I understand it, the earliest that we're going to return to work is when they're going to change or hopefully take away some of the social distancing measures on the 21st of June. So certainly I don't think we'll see a wholesale return to the office until certainly no earlier than that date, unless, of course, the vaccination programme continues its remarkable success and the government's able to roll forward some of the intentions. So I think certainly I think if you're a business now, I wouldn't be planning to have a wholesale return to your offices if people can work from home until kind of June at the earliest. Will people undertake workplace testing? I'm not so sure that that would be compulsory. I know the government's offering to support large employers who want to undertake testing, but I would be surprised if the government introduced obligations for obligatory workplace testing. I think it'll come down to employer choice. And as I said, I think I think employers forcing or requiring testing, I think is going to be difficult. Another interesting question about holiday leave. It's always holiday that gets everyone, gets all the typical, the tricky questions coming in. It's no wonder I spent most of April answering questions about furlough and holiday pay, looking at some of these. So if a business hasn't prevented an employee from taking annual leave due to COVID, does the employer have the right to deny an employee carrying over for 2 years? It's a really interesting question. I think we'll see some cases on this, because I think you'll be seeing cases as to where was the employee prevented from taking leave due to the impact of coronavirus. I think employment tribunals have sympathy for employees in those circumstances, but potentially if you could say to employees, well, we made you aware of your holiday entitlement, we made you aware that you could take your holiday entitlement, there was nothing to stop you taking that, even though there really wasn't anywhere for you to go for a period of months, but that still doesn't mean you're entitled to carry that over. But I think it would be very fact dependent, and I certainly wouldn't want to be the first employer testing an employment tribunal's thresholds on that one. Let me just see. There's plenty of IR35 questions coming in, but those are quite specific. So apologies if we don't answer those specifically. May well be by looking at this, we need to do an IR35 webinar revisited program. Perhaps we could put that together, I'm sure at fairly short notice. I've got some contacts who I'm sure would love to do that. So perhaps that's the better way to deal with some of those. Where do employers stand when an employee makes an application to continue to work from home after national lockdown is over? Well, that's going to be, I think, where we see lots more flexible working requests made. And certainly I think for employers who traditionally have resisted home working, we've almost had a mass social experiment, haven't we, imposed on us as to, home working. And by and large, it's worked effectively for many businesses. So I think if you're going to require employees to fully return, not consider any hybrid arrangements, and then face a flexible working request, you're going to have some really good answers as to why that flexible working can't continue, that home working can't continue in some capacity. Well, have you seen queries like that come in, Lindsay?
Yes, yeah, exactly. And I think obviously in some cases as well, you have to be mindful of any discrimination implications as well, because of which you would have had to have done anyway. But yeah, I think given that most employers have managed so well, and most employees have managed so well working from home, and the technology is so good nowadays, it's never been better, that you'd have to have a really good reason why not.
Yeah. I did mention, I think that's a good point. I think dealing with those requests and rejecting them is going to become more difficult. We've got a question here about do we think the rules on fire and rehire on new terms will change as a result of the current Tesco case? There are a significant number of organisations, British Gas being one of them, BA hit the headlines last year, who are imposing effectively changes to terms and conditions by giving employees notice with offer of re-engagement on new terms. At the end of that notice period, it's actually a way in which employers can introduce changes to terms and conditions. Often employers are aghast at the thought that it's a mechanism by which changes can be made. I don't think this government has really any appetite to start legislating around those sort of issues, restricting an employer's ability to change its terms and conditions of employment by giving notice with an offer of re-engagement on new terms. What you could do is bring in some support that says, and if they don't take up that offer, it's got to be treated as a redundancy situation with redundancy pay. That may make employers think a little bit more carefully before they do that. But other than that, I don't think the rules are going to change. I think we'll still be in the same position. And finally, just on IR35, a couple of questions have come in about liability, about it being passed up the chain. If you're the end user client and there's a number of entities you're paying, and then they're paying someone else, and that entity then pays the individual's personal service company, there is a risk of tax liability being passed up the chain if there's default in amongst that chain. So if the original party doesn't deduct the tax that should have been deducted, then HMRC can go back up the chain. It's not easy to do that, but it does expose you a little bit more as an organization. And if you're the end user client, I'd probably be carrying out a little bit more due diligence on those that you're contracting with, just to make sure you're happy and confident that they can make those payments and will make those payments. Otherwise, potentially liability gets passed up the chain to you. Well, I said we'd try and finish by 11:30. We're just coming up to that now. So I think we've dealt with lots of the questions there. What I'll try and do as well is if I've missed out on any, I'll pull together an FAQ list and perhaps circulate that as well. You've got obviously Lindsay and I's contact details on the screen. You know, we'd love to hear from you. Love to get some feedback on the webinar. I'm going to resist sending out a questionnaire, but what we will do is send out a copy of the recording and maybe deal with some questions as and when we get them, and then we shall hopefully have some more in the pipeline coming forward. So big thank you from me. Lindsay, thank you for presenting. That was a fascinating run through of some of those cases. Hopefully you stay in touch, and yeah, we'll hopefully speak to you soon. Thank you.